debating throughout the day. I think Heike Schweizer reminded us this morning that we're trying to develop a system of policy and enforcement which is effective and timely in relation to how digital markets developing. And I think the discussion has showed that we're talking around three components of the instrument we need to use. First of all, an active competition law enforcement policy with the aim of preventing infringements which may occur, for example, through anti-competitive measures, with the aim of restoring competition where there have been infringements which have harmed competition, with the possibility perhaps of forward-looking remedies as well. So first, enforcement of the competition law rules. Secondly, ex-ante regulation, where it can be defined in a way which allows it to provide a framework to make markets work effectively. And that presumes that everyone knows in advance, whether it's the regulator or the legislator, that there are certain problems which don't need further investigation, but for example, in the telecoms area, have given us have recognized the reality of the natural monopolies of many of the incumbents as far as the networks are concerned. In the energy area, the same thing. Without unbundling, it would be impossible to provide a framework for effectively functioning markets. Alongside that, there's been a lot of regulation which is ancillary to the basic issues of access to markets, portability, interoperability, and alongside that too, consumer protection laws and unfair trade protection practices. Now, all that ex-ante regulation presupposes that we know what the problems are and that they are sufficiently repetitive that the solutions can be provided in regulations concerned. Now, the third arm of any approach which is comprehensive to the issue of effectively functioning digital markets and other markets too, is whether there are issues, where there are situations where the sectors concerned raise problems of market functioning, where it's not clear what the precise solution is. It certainly may not involve any infringement, and it certainly by any individual companies. It may lead to future remedies which are industry-wide. It could indeed lead, as it has done in the energy sector, to more sectoral regulation based upon the results of any market investigation which is carried out. And that the new competition tool, insofar as it reflects the UK and other jurisdictions' experience on market investigations, demonstrates that there is a gap there, that in certain circumstances, markets are not working for the benefit of consumers and businesses, and therefore you need to investigate why it's not working and what the potential remedies are, with, of course, naturally, a due process to ensure that none of the rights of individual companies are harmed. I slightly disagree with Makis about the degree to which the Commission is reinventing itself through this sectoral, through the new competition tool. After all, we've had sectoral inquiries and market studies for a number of years. We've been benefiting from the influence of the UK regime and its positive advantages. And one can see that to a certain extent, the addition of a market investigation tool with the potential for installing industry-wide remedies is a natural complement to the sectoral inquiries which have already taken place in many areas, whether it's on e-commerce or whether it's on energy. So those are the three main components. But of course, we have already had in the application of Regulation 1762 and Regulation 1/2003, several pieces of, in fact, de facto sectoral regulation in terms of block exemptions. And those block exemptions have, generally speaking, put certain practices, conducts, agreements into, as the title of our sessions has indicated, some color zones. I'm not sure whether it's white and green or orange and gray or black and red, but more or less it is these things you can do, and we won't enforce any action against you. These things you definitely can't do, and in the middle we can discuss, and we may have to open an investigation. Now I'm joined today by four colleagues and eminent interveners in antitrust merger practice, as well as indeed in market investigations, who are going to give their views as to whether this mix of instruments, which is now proposed or looks like being proposed, seems to be the correct one. And they're going to draw on their experience of how we've been implementing the competition rules so far. And in the order which is indicated on the program, I'm going to ask Jean-François Bellis, first of all, to comment.
Yes, thank you, Philippe, and thank you also to the Institute for the invitation to participate in this interesting conference. Yes, I think it's useful to take a brief look at the past experience with indeed a form of ex-ante regulation. This lists of black, white, and gray clauses in so many block exemptions. And it's, for me, an example of the very clever use that the Commission has made of its exclusive power to grant exemptions, to engage in something that Nicolas Petit called in one of his books a form of contractual engineering. And to take full advantage of that exclusive exemption power, the Commission, as we know, developed the broadest possible definition of what is restriction of competition, essentially any restriction on the freedom of action of a company, so that an agreement between a manufacturer and a distributor, which was exclusive and did not contain any other restriction, was an agreement which infringed Article 85, paragraph 1, because the manufacturer had committed not to appoint other distributors. And so that meant that practically most commercial agreements ran the risk of being found restrictions of competition prohibited by Article 85, paragraph 1 and 2. And so we needed an exemption. And when we know the story of the 30,000 notifications which were made in the 16, and then this very special practice that the Commission developed of the block exemptions with their list of first black clauses, which were the clauses which prevented the grant of the exemption, white clauses, which were clauses which did not restrict competition, but the Commission felt it necessary to list them in order to exempt them in case any doubt was raised. And then you had this intermediate status, the gray clauses, which needed a notification, but if there was no reaction by the Commission within 6 months, they were deemed to be exempted. And so you had this enormous catalog, growing catalog of clauses with these different colors, which became, it was, I think the only EU competition law was the only competition law in the world which had that system, but you had to consider those clauses when you were assisting a client in drafting an agreement. Now, Philippe sent us a list of questions, and one of the questions is, well, was this system, of course, which was abandoned with modernization, the only clauses that survived modernization were the formerly black clauses, which are now called, this strange name, hardcore restrictions. Everything else disappeared. Of course, notifications disappeared. Exclusive exemption power of the Commission disappeared, and we now have a concept of restriction of competition, which is more mainstream. Now, did this system work? Was it effective? And I would say yes. Businesses very quickly understood which clauses they should avoid. So it worked extremely well. And the ones who ignored the message coming from the block exemptions were quickly called to order by the imposition of fines. So the system worked in a sense. Now, were there drawbacks with that system? And in my view, one of the problems of a system of clear black clauses is that it introduces rigidities in the application of the law from which we are still suffering today. Take resale price maintenance, RPM. Blacklisted almost from the outset, still regarded as a hardcore restriction. But then in the last version of the vertical guidelines, I think a lot of people were surprised to see that the Commission was prepared to accept that RPM might not always be anti-competitive. I guess that there was the influence of the economic literature on the subject, maybe also the influence of the US Supreme Court Legion case, which took RPM off the list of per se violations. And so in the guidelines, the Commission explained it was a very timid attempt at rehabilitating RPM, gave a few examples of situations where RPM would be lawful under EU competition law. But because this RPM has been regarded for such a long time as a black clause, in practice, it's extremely difficult to convince a competition authority, a court, that RPM should be allowed. And I think that this is, one of the drawbacks of attaching a stigma, blacklisting to a given practice. It's very difficult to remove that stigma, and so I think this is one of the lessons that we should keep in mind before drawing up new lists of black practices in the instruments which are being considered. Well, I will stop here. I have other ideas to share, but I will stop here. Thank you.
Do you think that these proposals in their three components of new competition, the ex-ante regulation strengthening and the active competition law are going in the
Yes, well, I'm concerned about, well, of course, we don't know exactly what will be proposed next month, but there have been leaks, etc., so we have heard many things. I'm a bit concerned about the gatekeeper regulation, because if in that regulation, you will already find a list of black practices. And so the idea would be to have black practices, things that you cannot do, white practices, things that you have to do, and maybe there would be a gray list in between. But isn't it a bit too early to already have such a list? I could understand that an enabling regulation is adopted, authorizing the Commission to draw up those lists. But isn't it a bit too soon to do that? And how would this prohibition look like? I mean, would it be like the 10 digital commandments of the EU? Thou shalt not self-prefer, these kind of things. But these are complex practices. Can you have such simple commands? Now, I fully understand the need for this legislative intervention, because people have spoken about regulatory gaps. Maybe there are some regulatory gaps, but I see a big jurisdictional gap. Member states are toying with all those ideas, and the EU has no tool to deal with them. So there is a huge risk of divergences among member states, and even worse, a risk of irrelevance at the EU level. So I understand the need for these instruments, but isn't it a bit too soon to have a gatekeeper regulation with already a list of things to do and not to do?
It sounds like, according to Jean-François, the grey and the new black. So, Christopher, do you think we've got the right balance in what's expected as the proposals?
Well, thank you. Thank you, Philip. I think I might just echo first Jean-François' last comment, that if you remember all those years back, and probably only you and Jean-François and me can still remember the early days, those block exemption regulations were built on a considerable amount of experience in studying practices and in previous decisions and so forth. So it is quite important to have that experience before you arrive at any sort of list. That said, and with your permission, perhaps I could just pick up one or two points on the wider question of the new competition tool and the market investigation that is a market investigation regime that is contemplated. And just to begin, could I just underline a couple of ironies? One is that the UK, which is apparently being used as an example of such a jurisdiction, will not actually be participating in it. And it is always very difficult to borrow, I think, somebody else's jurisdiction without fully understanding the background and the legal culture that goes with it. That said, the second irony, I think, is that in relation to digital markets in particular, the UK has decided not to go down the road of the market investigation. What has happened there is that there's been not a market investigation, but a market study of digital advertising, as a result of which the UK government is setting up a digital task force, which combines competition, the communications regulator, and data protection regulation, to arrive at a bespoke pro-competitive regulatory regime. And that will be subject, of course, to a full parliamentary process and scrutiny. So perhaps we should not confuse the two separate issues of whether you need a new competition tool and whether you need a regulatory structure for digital markets. In relation to the new competition tool, it is probably worth remembering that the UK regime has two stages. The first stage is a market study. And as you have so correctly pointed out, the Commission has already got powers to have market studies and has conducted very successful market studies in the past, which have led to some quite considerable improvements. I would add to the ones you've already mentioned, the pharma sector study some years ago, which resulted in a great deal of cleanup of settlement agreements and practices like evergreening and so forth. In the UK, a market investigation normally follows a market study, but not necessarily. We've already mentioned the digital market study, which is not being followed by a market investigation. And another recent example is the audit study into the big 4 audit firms, which again is going to be the subject of a further regulatory reforms conducted by a regulator in that sector. And that underlines the issue that many of these studies and issues are not just competition issues. As has already been said, they may well be consumer protection issues, data protection issues, financial probity issues, company law issues, and many other things. So it is perhaps a mistake to call this instrument, if you're going to have it, a new competition tool, as distinct from a wider market investigation tool. And to pick up a point that I think Mario Siragusa made at the beginning of this colloque about the origin of the UK regime, it goes back to 1948. And for the first 60 years of its existence, it was a public interest regime that enabled investigations to be conducted into all kinds of things. It was only in 2003 when it suddenly became fashionable to think that competition was the solution to every known problem on the planet, that the regime was reorientated to be centered on competition problems. The current fashion, I think, in the UK, particularly under the impact of the pandemic, is now moving in the opposite direction, where it is no longer thought that competition as such can solve problems. But what you need is a cross-disciplinary regime that can look at all angles of a particular situation, which is why in the digital space, the proposed specific regulation will comprise not only competition authorities, but also representatives of Ofcom and also the data protection authorities, because there are clear cross-disciplinary issues in such a space. So I would urge you to design a regime that is wider than a pure competition tool. So then the question is, why are you doing this, or why is one doing this in the first place? And it is said that there could be serious gaps that a tool like this could fill, particularly, for example, in relation to the regulation of oligopolies or the suspicion of tacit collusion, for example. And indeed, perhaps there is a certain gap. And we've seen investigations into in the UK, and for example, into energy companies, into banks, into supermarkets, petrol and diesel retailing, to see what can be done. And the answer is, in many of these so-called oligopolistic industries, very little. We've seen a number of very, very expensive, long-winded inquiries actually produce very little, because no one has yet thought out what is actually the answer to an oligopolistic situation, except perhaps sectoral regulation in those sectors that are suitable for regulation. In other words, it is often the case that anyone can see in 5 minutes that there might be a competition problem. The issue is always what you do about it. And in the CMA, for example, has often found, or recently found in several cases, the real problem is consumer inertia. And what has been said earlier in this colloque, how can you deal with consumer inertia? You can publish all the information that you wish, but you are up against real life. So what I would say to those who see this regime as filling a gap, that it's not as necessarily a silver bullet. There are certain features of the landscape that just do not lend themselves to quick solutions, and to introduce a new tool, especially if it's narrowly focused on competition, as distinct from taking into account other interests, may not actually result in anything very much. It may be an extremely expensive and ambitious exercise for very little actual gain. That said, and these are my last remarks, if you'll forgive me, there are some advantages in having such a regime. First of all, the threat of an investigation, surprisingly enough, often produces a result without you actually needing to do anything. You don't have to balance angels on pins in order to decide on object or effect. You don't have to spend years debating the existence of a dominant position. You don't have a heavy sanctions regime where you fine people billions. You don't have human rights defenses. You just get on and find an answer. And that properly organized, those are important advantages, and it enables prompt invention. Jean-Francois will know of a certain case we both know something about, where the facts arose 20 years ago, and they're still before the European courts. So this is the kind of thing that is quite important. So what I would say is there are some advantages. Don't exaggerate them, and make it a wider tool than pure competition. I will stop.
So you recommended a wider tool without prejudice to what the instrument is which you use to solve the problem, whether it's competition or in other areas of regulation. You also think the threat of the investigation is a useful element. The only residual thought I had is whether if you're going to have such an instrument, would you not also include in it the possibility of imposing industry-wide remedies without having to prove either dominance, for example, or the existence of an infringement?
Yes, I think you would include that. And you might want to include even a divestment remedy. Because I think there is a question as to whether you've got a divestment remedy under Article 102. The divestment remedy in the UK has only been used in recent years once, when they split up the 3 London airports from common ownership. But it's a useful reserve power for occasional use. So I think that's what I'd say. Are we still connected?
Sorry, Christopher, I missed those last remarks there, but I'm going to now pass the floor to Jim Bennett, who's on the phone, I think, somewhere, if I can look across the screen. No, he just looked at, so in which case, Jorge, could you go ahead?
Thank you very much, Philip, and thank you to the European University Institute for this opportunity and to share this panel with such distinguished speakers. So where are we here? So Philip, do you want me to continue, or do you want to move
Yeah,
to Jim?
Jim is coming. I'm sorry, Jim. I'll have to come in afterwards because I've given the floor to.
Okay, fine.
Very good. So I was asking, why are we here? Why are we talking about this? Well, I think that we are talking about this because there is a consensus, or there seems to be a consensus, about the inefficiency of existing ex post intervention tools to deal with, among other things, some forms of unilateral conduct in digital markets. And not only in digital markets, but mainly in digital markets. I think that this consensus suggests that intervention, ex post intervention in these markets is too little, too late, and quite ineffective in the sense that has not led to or resulted in remedies that have corrected the sort of problems that triggered the intervention in the first place. And whereas not everybody agrees with this consensus, the train seems to have left the station. And as Jean-Francois was mentioning before, a number of national competition authorities have moved forward. And to some extent, the Commission has no choice but to follow suit if it wants to preserve also, among other things, the internal market. And so what are the answers to that? Given that if we accept that consensus, that what can we do? Well, we have a tool that we consider inefficient, so we need to look for other tools. And initially there were kind of, we were considering two alternatives. One was ex-ante regulation. The other one was to introduce this new competition tool, this market investigation tool. Now, these are different tools. The ex-ante regulation first is truly ex-ante. And secondly, and most importantly, it focuses on companies. You are regulating the behavior of certain companies. Whereas the market investigation tool, as far as I understand it, is a kind of a mixture of ex-ante, ex-post, and most importantly, it focuses on markets, on structural features in markets that impede effective competition. Now we seem to be talking about the Digital Markets Act, which is going to combine the two, and that is, you know, I'm eager to see what is going to be produced. But this is to me quite interesting and challenging because they are different tools. Now, why regulation? Those that favor regulation think that regulation is the right tool for two reasons. One is because there are certain behaviors by qualified companies, let's call them gatekeepers, for example, which are necessarily welfare reducing. And I want to emphasize necessarily, they're per se anti-competitive. And secondly, because with respect to those unilateral conducts, these certain behaviors that are necessarily welfare reducing, existing tools are highly inefficient, either because they are too slow or because they cannot produce effective remedies. If you accept that, then it's logical that the consequence is the creation of whitelists and blacklists. If for that, what we understand is a series of obligations and a series of prohibitions. But those obligations and prohibitions, when we judge them, when we see the list finally, and we try to assess whether those lists make sense, we will need to go back and ask, is this the sort of behavior that necessarily would produce anti-competitive effects? Do we need those prohibitions because it's clear and unambiguous that if companies, these qualified companies, these gatekeepers behave in a different way, they would result in, their actions will result in a consumer welfare loss? Yes and no. Now, in this attempt to merge regulation with a new competition tool, we have this gray list, and which emerges on top of the blacklist and the whitelist. Now, the gray list cannot really be explained as an instrument in regulation, because if the reason why we regulate is because there are certain behaviors that necessarily are going to produce anti-competitive effects, you have to ban them, period. You have to tell companies don't do it or do the opposite. But what is this gray list? And in documents that have been leaked, they're, and I'm not sure exactly by whom and whether they are credible, but things that have appeared in my table, these gray lists are very, very confusing. I mean, they appear to be also prohibitions, but is the prohibition of a lesser intensity or what it is? And some people say they're not prohibitions. These are issues that are going to be further investigated. Okay, my understanding leads me then to think, well, that may mean that these are not prohibitions by object, but they are kind of prohibitions by effect. But if that requires an effect analysis, then they cannot be part of an ex-ante regulation. They have to be something else. They have to be part of some form of market investigation, but not even so, because a market investigation, as I mentioned before, is about the structural characteristics of markets that impede effective competition, whereas this gray list will affect the gatekeepers. So this is kind of, maybe it's going to be perfect and it's going to be extremely good looking, and but in principle, to me, it seems very confusing and could become a monster. And that leads me to the last point that I want to make at this stage. If we're going to impose these blacklists and white lists and gray lists on these qualified companies, we need to go beyond just calling them gatekeepers. We need to establish clear criteria by which a company is going to be denominated a gatekeeper. Because in a sense, as I see it, what we are doing through the blacklist, whitelist, and gray list is extending the special responsibility of dominant firms to these so-called gatekeeper firms. And so we will need to define what is a gatekeeper. And that means that we need to answer a number of questions. I'm not going to try to answer them, but I'm going to try to pose them. And with that, we'll conclude. First, a gatekeeper where? And that means that I believe that we're going to have to define markets. A gatekeeper with respect to whom? These markets, these platforms that operate in digital markets have multiple sides. Which side is the one that is being exposed to the gatekeeper? Second set of questions. Gatekeepers have bargaining power. And then how are we going to measure that bargaining power? And to what extent that bargaining power relates to dominance, to the ability to act with independence of competitors? It has to be short of that, because otherwise the gatekeeper will be a dominant company and then end of the story. So I think that we need to be precise about what we mean about that. We need to understand the extent to which the gatekeeper actions hurt one side of the market but benefit the other side of the market, or are we going to ignore that? That's something that we need to be clear about. And finally, I would say that before we conclude that a company is a gatekeeper, we will need to do some form of error cost assessment. Because when we are, denoting somebody as a gatekeeper and introducing all these obligations and prohibitions, those may lead to type 1 errors. Now, maybe those type 1 errors are irrelevant and we don't need to care about that. And then we can be expansive. But depending on how we assess all these errors that we could point in one direction or the other, we may be over-inclusive or under-inclusive in our definition of gatekeepers. So I'm looking with great interest what is going to come next week. At this point, I'm utterly confused. The documents that have been leaked are, very confusing. So I think that this is going to be a fascinating adventure next, in a couple of weeks. We're going to have a lot to debate about, and I hope that the University Institute in Fiesole, once the COVID is over, can organize something physically where we can debate that over a nice risotto. Thank you very much.
In brief, what you say, Jorge, is not only are the conducts and structures in the gray zone for digital purposes, but market definition is market definitions as well. The only question I was thinking there is, supposing the commission had actually said we're going to produce guidelines on these issues, not regulation, but guidelines, and that we are, as some have suggested, going to reverse the burden of proof in respect of some things in the gray zone. That is, once it is acknowledged that you are a gatekeeper and you have significant market power, then it is up to you to prove that what you are actually doing is not anti-competitive. Do you think that would be a better approach, or is now the train left the station for regulations so quickly that we're bound to be talking about it in statutory terms?
Well, look, I don't know, and it may be that the gray list is about that. And I don't know exactly what the gray list is going to be, but one option for the gray list would be to have a reversal of presumptions. Black lists clear, white lists clear, gray list reversal of presumptions. But if that is going to be the case, then I think that what the Commission would have to do is to persuade the market in general that the rebuttals are possible, that are not just theoretical, possibilities, but effective possibilities. And I think that that would require perhaps some guidelines on how they are going to treat efficiencies and assess efficiencies in the context of this new instrument.
So the terms of a regulation may not be may in principle be harder than guidelines, but in practice, the result may be the same. Just thinking about the comparison with the telecom sector, where we at least have the recognition of special market power, SMP, whatever, and then an agreed list of areas where price regulation or whatever is necessary, mostly related to access rather than anything else. Here it's slightly more problematic than simply access. But it is not impossible if one could actually get a definition of what a gatekeeper is and how large a platform is, for there to be a regular updating of that list, just as there is now under telecoms regulation.
Agreed.
So let's pass the floor to Jim, if you can hear me.
I can hear you.
Yeah.
Can you hear me?
Welcome back. Sorry that we missed.
No problem. First of all, my apologies.
The floor is yours.
Apologies for being invisible. And before I start, just to quickly answer Philip's question whether the train has left the station. I mean, I think it has, and I think the reason why it has is because if the Commission doesn't do something in this area, the member states will. And so I think that's a bit of the dynamic that's pushing the Commission's move aggressively into this area. I want to talk about a different aspect of regulation. I was really surprised when Philip sent his questions referring to the block exemption regulations, because for me, those are very general, broad principles, whether right or wrong, ingrained or not. But we've had very specific experience with very precise industry regulation, for instance, in the computer reservation systems area, where the Commission adopted a code of conduct. And I think it's interesting to reflect on that experience for the reasons I'll now explain. Essentially, and the code of conduct wasn't adopted pursuant to the competition provisions of the Commission, and it wasn't administered by the Commission. It was administered by what was then called DG Tren, I think. But it had a competition basis, and the principal basis was the concern about self-preferencing, where you had airlines that owned the reservation systems and without some form of intervention would only list or would give preferential listing of their flights and therefore disadvantage their competitors. And that was a real concern. So the regulation was adopted, or the code of conduct was adopted. And the consequence of that was that the airlines that had spent a fortune to develop these computer reservation systems sold them because they weren't going to get the advantage that they'd hoped to get. And the unfortunate consequences of the airlines when they did that, and this is a little bit of a story about unintended consequences, both on the regulatory side and on the industrial side, is that they created a monstrosity because computer reservation systems became a very important cost to them for selling their tickets. Two other things about this experience. One is unintended consequences. For instance, if you said to a platform, you can't both sell your products and other parties' products, and you have to divest your sales platform from your own downstream business, that would be a little bit the model of the computer reservation system. And I'm not sure what it would produce if one had a rule like that. The other interesting thing is that one of the key provisions of this code of conduct was that the computer reservation systems would not charge discriminatory or would not engage in discriminatory or unfair practices, which is really not a regulatory solution. Okay, discrimination you might be able to find, but unfair, we're getting into realms where I think economists and competition lawyers normally get nervous. The last point is that the regulation still, code of conduct is not a regulation, it's still focused basically on this problem of self-preferencing. After that's no longer a problem in the industry. The problems the industry faces are whether airlines, for instance, can withhold some of their itinerary, some of their offers from the CRS or not, and that becomes a negotiation between the airline and the reservation system. Okay, why have I gone through all of this? One, because I think it's important to study regulatory experience that we've had, and this area seems to get ignored, partly because it wasn't run by DG Comp and partly for whatever reasons. And two, it sort of illustrates that sometimes if you intervene in a regulatory way, there may be unintended or unexpected consequences. Then the question is, do you produce lesser problems or more problems by that intervention? But in any event, I mean, I think people should reflect on that experience and put that into part of the discussion that's going on now. That's all I have to say.
Thank you, Jim. We've all been talking rather skeptically about regulation in relation to the digital area. At the same time, we are pretty aware, as Jim has also referred to as well, that in the telecoms area, in the energy area, in the air transport area, we have regulation alongside competition rules. We are happy with that. In the UK, there are plenty of regulators operating alongside the CMA to ensure that markets work effectively. And so we play the devil's advocate in that sense. Well, shouldn't there be something in the digital area, even if we don't get it right the first time, in order for us to move on? And that's the political pressure too. You've got to do something. And maybe one could say, let's have a new competition tool first of all, and then we find out what we should propose, and then we re-regulate. But the time has gone for that too. Shouldn't we be actually trying to draft something, however, as Jorge says, however ridiculous some of the proposals have been, to start the ball rolling a bit? I start with Jean-Francois as a comment for that.
Well, we have current cases that deal with some of those issues, self-preferencing. There is the Google case, there is the Amazon investigation, which just started about sharing of use of data. So I don't know what kind of blacklist the Commission has in mind, but is it really necessary to already draw up that blacklist? So, for example, when you look at other sectors like the pharmaceutical sector, there was a sector inquiry in that area. The new competition tool, which might be called the MIR for the digital sector, is essentially a sector inquiry with teeth, so with remedies. So in the pharmaceutical sector, the sector inquiry showed that there were problems with competition from generics. And there were a few cases about pay for delay agreements, and there have been similar cases at national level, and so I think have thrown enough light about when that practice is illegal, and the rule has been clarified by those cases, and you can anticipate that companies will pay attention to this and will adjust, and have already adjusted their conduct accordingly. I've seen some companies indeed doing this, paying attention to those cases. So, would it have been necessary to have a regulation for the pharmaceutical sector, explaining pay for delay agreements under certain conditions are a no-no. I mean, can't that conclusion be drawn from the cases that were brought? But again, we are talking about a blacklist that nobody has seen. So it's when I will see, maybe I will have a different impression about this initiative. But before we draw up those lists, I mean, so just bringing cases isn't that enough?
Bringing cases plus the block exemptions, which we've referred to earlier, and any guidelines which exist. By the way, in the spring of next year, we will be organizing in Florence another competition law workshop with heads of agencies and judges and practitioners, and hopefully by then we'll be able to have an open, closed debate within four walls, but a very open debate amongst heads of agencies about the direction to go in. But on that basic question, Christopher, do you think we do we really need this?
Well, I would go slowly. And the UK's experience is to develop a code of conduct and to take it step by step. So I would be hesitant to rush in at the beginning with some sort of blacklist. I think you should also bear in mind Jean-Francois's point about rigidity and about the fast-moving nature of this sector. And also, although it's sometimes painful to remember, many sectors want to be regulated. Why do they want to be regulated? Because it makes it very difficult for new entrants to come in, because they have to support the costs and the difficulties of regulation. We all know in some sectors, companies have whole departments devoted to managing the regulator. So it's not again a silver bullet. And I think the UK approach would be to take things steadily. That said, if I may respectfully disagree with Jean-Francois on something like the pay for delay agreements, that is a classic case of the interface between IP rights and competition law, which is quite difficult to solve under competition law, as the US Supreme Court has found in the Act-Harvis judgment. Is it object? Is it effect? Can you really say it always was the object if you're trying legitimately to settle a case? So that may actually be an area where, without having to answer that question, it's easier to develop a set of guidelines through a code of conduct and a market investigation tool than it is to use the fairly blunt weapon of Article 101. I think those would be my comments.
Well, Jorge, we've all read Furman, we've all read the reports prepared by Heike and others, Scott Morton, etc., etc. But this avalanche of analysis, isn't it time that someone did something? And why can't we do something in the digital area, which we have already been prepared to do with telecoms, with energy, and with transport?
I agree. I think that something is going to be done, and I think that, as I said before, I think that the train has left the station. What we need to make sure is that what is done is it doesn't do harm, and help us go forward in a consumer welfare enhancing way. And that to me means that perhaps it's too early to think about black, white, or gray lists, and it's more time to think about how are we going to define or identify the markets where we're going to place emphasis and and that we try to regulate. How are we going to define gatekeepers? What are the criteria that we are going to be using? What is a black list? What is a white list? What is a gray list? What kind of criteria have to be used to determine whether a conduct should be blacklisted or whitelisted or gray listed? What are the opportunities that we're going to give to companies that have been appointed or identified as gatekeepers to argue that these behaviors that are proposed for a blacklist shouldn't be in the blacklist because they are not per se anti-competitive? How are we going to deal with that process so that eventually we come and produce blacklist, whitelist, and gray list that make sense? And then what is the process by which this is going to be done over time? What are the periods of review and which institutions they're going to do all that? It seems to me that is a bit premature to talk about what are the sorts of conducts that should be classified where without understanding all that. And I would, I'm not a lawyer, and therefore I may be missing something important here, but I think that before we get into contact and substance, this time an economist is going to call for a little bit of process in how we are going to define all these and definitions, which may be what the lawyers call for, but this time as an economist, I think that they are badly needed.
Sounds if you're going for the gradual approach which Christopher's referred to, that
definitely
we'll start with defining the terms and then see whether they can be applied effectively, including on blacklists or grey lists or whatever. Jim, have you any comments? I mean, we've talked about the train leaving the station. Do you honestly feel that regulation in the digital area is going to be corrosive? Can it really be harmful? Have we lost? Hold on. Jim, can you? Oh, Jim, can you unmute? Can we unmute Jim? No. In which case, we'll continue with Jim providing an intelligent configuration around us. I want to turn to another question, which has been raised by both economists and lawyers, which is the extent to which ex-ante regulation either promotes or frustrates innovation. Now, I happen to have seen a report which my colleagues in Auxerre had been asked to produce this week. Obviously, it's been produced in response to a request from a company, and the company concerned is Amazon. So I be fully transparent about this. But the thesis there is that the assumption of the regulation which is proposed for gatekeepers and large platforms is that these are large trees which are frustrating the innovation of all the smaller trees in the forest below them. And that it is necessary to control the growth of these large trees in order to let the smaller bushes develop and innovate. The counter thesis to that is, well, actually, no, this regulation is actually going to disincentivize innovation by large companies, and actually also act as some degree of disincentive to the smaller companies who tend to want to innovate drastically and challenge the big companies rather than they themselves, the larger ones, doing incremental innovation. Now, there's no clear answer to that, but what is your feeling each of you on this issue of the incentives or disincentives to innovation. Jean-François, first of all.
Well, it's really a difficult question that you are asking, and I think it's a question where probably Jorge would feel more at ease than me on this issue. When Nicolas Petit published recently a very interesting book, in fact, which I read last week about the kind of competition, and maybe you should intervene in this discussion about the kind of competition that in which those platforms are engaged, something that he called a oligopoly, so where each of the platforms is constantly looking for new markets into which to enter, and so in fact there is a form of competition among all those platforms, which does not correspond to our traditional ways of defining the relevant market, and sometimes there are platforms which are unavoidable because they are really very, very efficient. So looking at my own experience with the Microsoft case, the fact that, Windows was such a dominant platform also made it easy for various various OEM brands to communicate with one another. Maybe it was kind of unavoidable monopoly. But I will really stop here because I have the impression that I am really outside of my field of competence, and I will defer to more expert participants on this issue in this panel.
That would be very modest after your engagement in so many cases involving these issues. Christopher, could I have you disappeared? Maybe. So I'm going to. Christopher's there. Yeah.
Here we are. Yeah. Philip, I think the jury is out on this. Why is there no European company in the top 20 digital players worldwide? Is it because we've not had regulation, or is it because unregulated entrepreneurial societies elsewhere have got ahead of us? I think it's at least arguable that regulation is actually more of an inhibitor than a promoter of innovation. Jean-François mentions Microsoft. Some of us are old enough to go back to the days when the dominant company was Xerox. Where is Xerox now? Then there was the IBM case in the 1980s, the big blue. Where is IBM now? Where is Microsoft now? Do these problems solve themselves? Were they ever solved by regulation in the past? Or are they actually solved by entrepreneurs developing new solutions and coming up with new ideas? I leave that question hanging in the air.
Including entrepreneurs within some of the firms who have been accused of being dominant, who have been able to change their business models sufficiently to respond to what the market seems to want. Now, Jim, I'm going to take Jim, Jorge, before you, because Jim, I first of all put the question earlier on, the devil's advocate question: why don't we have digital regulation now? We've got it in so many other areas. And the second question I had was simply on the issue of innovation. Can we really say that the larger companies are frustrating innovation overall?
Okay, Philip, I think that, the question that you're asking is super difficult, and I don't think that there is established answer in the economics literature. I think that you would have people arguing one way or the other. I think that there is a sense that competition fosters innovation, and I agree with that. But it is true also that when you deprive the company from the returns of its innovation, then you may have a disincentive effect that you need to take into account. And if you do too much to facilitate the life of the competitors, then maybe the competitors don't invest that much. What I would say is that I think that in many of the cases that are currently being discussed involving the big tech companies, you really need to go to the details and to the specifics of the case. And the answer is going to be very difficult from an ex-ante perspective. I mean, let me just give a couple of examples. So, for example, with respect to conduct that affects, I don't know, the app stores, allegations that those made by Epic that Apple and Google are distorting competition by restricting access or increasing the cost of access or the cost of doing business in their app stores. I think that then what you need to think is, you need to think about the incentives to innovate of the app stores, developers, and then against the incentives to innovate of the app developers. If you move to the Amazon case, then what you have is, the incentives to invest in an app platform like Amazon vis-a-vis the incentives of the third-party sellers to develop new products or to sell new products in the platform. And the balancing of these exercises, and by the way, I should say that I'm involved in these cases myself, but the exercises are impossible to establish ex ante. It depends a lot on each of the cases, on the features of these particular cases. So I am dubious that we are going with what we know at this stage, be able to be very precise and very effective if we leave this to we try to resolve that through ex ante rules. So with respect to these things, that's why I think that we need to be very, very careful and only intervene when we are certain that that the type 1 error is limited. So we can make very significant mistakes.
Thanks. Schuman, can you hear it?
Yeah, no, I'm back.
Right, thanks. Welcome back.
Thank you.
You heard the two branches of the questions there. First of all, isn't it inevitable that we try to deal with the digital sector by regulation, even if we know that the first attempt will not be perfect? And secondly, what about this issue of frustration of innovation?
I mean, on the first point, I think it's a political issue, so it's going to happen and mistakes will be made. I would tend to, side more with Christopher and Jorge and everybody actually on the panel that people should go slowly and be prudent. And I think Chris's point that before you start to deal with the problem, address the question, what's the solution first? On the incentives to innovation, I think that's a very, very complex question. I'm sure the literature is mixed on it, and it's very complex. The airlines never would have developed the CRS systems if they thought they were going to have to divest them. But I think that's too complex a question for a lawyer to answer.
That's impossible. I thought lawyers could answer every question.
Yeah, but when they try and do it honestly, it's a different story.
An honest lawyer. Listen, I just want to turn to, in the last 10 or 15 minutes we've got together, to some of the process issues, which of course Heike also reminded us of earlier on. Christopher, well, in UK terms, it's fair to say, is it not, that market investigations which resulted in the imposition of remedies were extremely, extremely controversial and took a lot of resources from both the authorities and from the side of the so-called defending companies. I just wonder how that translates into a European situation, where European authorities, by definition, are regarded more skeptically than national authorities.
Well, I think it is an element to be considered. The UK cases of which you speak, I think, are involved significant remedies, and they were therefore contested by the parties through the courts in judicial review. And the parties, to some extent, succeeded, and to some extent did not succeed. So I think you're probably going to find a position where if there are serious remedies, there's got to be a judicial process. And I'd have thought that the European process on the whole is fairly slow and fairly inadapted to producing quick results. So that's a feature that has to be borne in mind. But unfortunately, or fortunately or unfortunately, if you are going to have a regime with teeth, you have to provide some remedies, and that's just a fact of life. But you do need to provide quicker and probably more comprehensive system of remedies than the European system presently provides. That's what I think I would say on that. Don't know whether you heard that, did you?
Yeah, I did. I'm just trying to regularly unmute myself. No, I think that one of the issues surely must be, if we want timely and effective and efficient intervention, potentially a market investigation which leads to further regulation, such as in energy, from the German cases of network unbundling to the third energy package. It would be a more realistic and quicker route than the route of going through the European Court to defend remedies which are decided on the basis of the competition tool. What do you think about that, Christopher?
Yes, I think there's something in that. I think, for example, to take another area, if the interchange fees had been regulated as they later were by the interchange regulation, that would have saved an enormous amount of time and effort in bringing all those antitrust cases, and indeed the subsequent actions for damages that have been proliferating all over the world ever since, which is not in the end a particularly good use of resources in my view. So I think the point you're making, Philip, which is a good point, is that there are more ways of skinning a cat than one, and one should exhaust all possibilities. For example, the earlier example given of a worry about cross ownership, for example, could be dealt with by reforming the merger regulation to take in material influence, for example.
Yeah.
It's just one thing to think about. You've got a toolkit here, you've got a box. Don't rush towards one particular large hammer before you've exhausted all your little other screwdrivers and other implements. That's what I would say.
There are two instruments which are under review at the moment. One is the market definition notice, and the other is whether or not mergers of a certain size can be caught by the existing thresholds, etc. Now, national authorities have tried to deal with that, and the Commission has also, I think, gone in parallel on a constructive path in making sure that referrals are used, referral procedures are used intelligently on that. Isn't something on the merger front, in terms of merger control, isn't that something missing from this package in the digital area? Jean-François first of all, and then Jorge.
Well, I mean, so you are picking another very controversial subject, merger control after Siemens Alstom. So I think that the Commission already has enough on its plate without, adding merger control to the digital discussion. You asked the question about the discussion on the market definition notice. I think for me that's really a it's a non-issue. Of course, it was something which I guess to the member states who were complaining about Siemens Alstom, bone, if I may use that expression, had to be thrown. So the market definition notice was a convenient subject to look at again. But of course, whatever changes are made to that notice will not address the problems, which are serious, very serious ones of how merger control should be applied in a world where competition takes place at the global level, and whether then indeed we should not be more lenient on some concentrations that allow the creation of European champions, even if that means maybe reducing competition somehow in the internal market. But this is a discussion which has industrial policy angles, geopolitical angles, which have nothing to do with pure competition law technique. But I found it interesting that industrial policy is a subject which is again fashionable. I remember the battles in the old days between, it was not called DG Com at the time, it was DG4, and then DG Industry. I don't remember its number. Exactly. And the battles between the two commissioners, and of course, all of that fell out of fashion for a number of decades, but this is coming back. So there is also that industrial policy dimension to the digital debate, but the proposals which are being put on the table look more like technical proposals where you find elements of competition, but also elements of something else. The gatekeeper regulation would be addressed at unfair practices of the gatekeeper platform. So you have issues which are not just issues of exclusionary relating to exclusionary practices, but also there would be an aspect of unfairness, of exploitative abuse, so which is also a new interesting development, because Article 102 used to deal with exploitative abuse. Is also, that was something which was quickly out of fashion. There was the United Brands case where that was the Article 86 was used to deal with abusive pricing, but then again for many decades it was just used as a kind of monopolization, anti-monopolization provision. But again, we are taking ideas which were toyed with several decades ago are coming back and being discussed again.
Yeah, it's fair to say that issues like killer acquisitions or trying to anticipate the potential competition from small companies which are coming up in the market. Those do relate to merger control in the classic sense.
Right. Yes, indeed. But there, I was surprised to see that, in fact, the Commission was not interested in changing the turnover thresholds. It felt confident enough in the referral process to be able to deal with that kind of acquisition. So it's.
Seems to be dealing with it in a pragmatic way, using the referral processes and leaving the national authorities to work out how they deal with it. Jorge, have you any? I'll come back to the issue of the international repercussions of digital regulation in Europe later. But Jorge, what do you feel about? Should merger control have been part of this package?
Well, I think that in one of the documents that I have seen, one of these leaked documents, where there is as part of the black/white list, there is an obligation on the part of gatekeepers to notify any planned mergers and acquisitions. I'm not sure exactly what happens after you have notified, given that it has no suspensive effect. So, you know, I'm saying this because I don't think that it's completely outside of the remit of the current regulation. In principle, one could think one day that you could prohibit all horizontal mergers by gatekeepers. You know, I think it would be crazy, but it's something that it could fit into the scheme as we see today. And there are out there a number of people, especially a number of well-known economists that advocate in favor of that. Former chief economists, well-known practitioners that argue that we should you know, make it impossible for these firms to merge and to acquire startups. The consensus there is much less clear. I think that the consensus that we need to go beyond ex post intervention tools in digital markets. I think that there the train has not left the station. It's still there and needs to be debated, especially because I think that the only solution, or the only way that I think that one could cope with those concerns, in my opinion, would be a reversal of the burden of proof with respect to horizontal mergers. But again, I would say there, as I said before, if anyone is playing with that, then we would need to make sure that efficiencies are given proper consideration, because otherwise, you know, what is a reversal of the burden of proof ends up in practice being an outright prohibition. So I think that if I am cautious with respect to expanding unilateral conduct obligations, I am even more conscious about playing or tweaking the merger control tool in such a way.
Do you agree with that? Sorry. Do you agree with that, Christopher?
Yes, I think on the merger tool, one should again be hesitant, though I think it's fair to say in the past that various mergers have got through without proper scrutiny that are perhaps regretted a little bit now. Again, the incentives are very difficult, I think, in this area, because it's very difficult to know whether a small startup is going to succeed or not. And there is the incentive of the starters upper and the incentive of the acquirer and so forth. So that is a difficult area, and I would tend to leave it where it is at the moment. Whether we should move back to exploitative abuses in some way, I think, is a question perhaps not for today, but it's not that far down the line. In Great Britain in the 19th century, when the new technology of the railways was sweeping the country, the government finally said you can earn 10% on capital, and after that you'll give it all to us, please. I mean, an amazingly early regulatory intervention in a different situation, but one where new technology was getting out of control and people were making unreasonable amounts of money. I mean, we're not there yet, but it's exploitation, I think, is in the back of everybody's minds. We'll see whether, and there is some sign that excess pricing, particularly in the pharmaceutical area, is back on the agenda. having slept for 40 years in the cradle of the bananas in United Brands. So we shall see. There's a lot of developments to come.
That's for the next webinar. Jen, have you any comment on that issue?
Can you hear me, Philip?
No me ven porque dice que el hospedador ha detenido mi vídeo.
Can you hear?
Yeah.
Okay, no, I don't have any comment on that, but I want to go back to a point that's come up repeatedly in discussing the experience with regulations, citing telecoms and energy. Those, I think, were sectors where the problems were much clearer and the solutions much clearer, and the regulatory and competitional interventions much more successful. I think when you get into digital markets, you have a much, much more complicated situation with many different parameters. And so I don't think those two experiences are really relevant to the present discussion.
Fine. I'm just going to end with a very quick comment from everyone on the issue which Jean-Francois referred to, which is what is the international of what plans here is? Will this have a negative impact on the growth of and the development of the digital economy in Europe? We've had a GDPR. We've had all sorts of other things going on in the regulatory area in Europe. They tend to be replicated by a lot of other places, except for those where the companies concerned who need to be regulated are actually located in the US. So I'm a bit skeptical about whether that's Europe showing the lead in regulation in this area, even if it gets it wrong. Is that going to be that bad? What do you think, Jean-François?
Well, I think that well, the ambition of being the leading regulator model for the world in regulation, I don't see this as a wise ambition for the EU. I think it should have the ambition of being a world leader also in technology and other sectors of industry. So I think that we have, because indeed we have heard this for a number of years. In Europe we should be so proud. We have the highest fines in the world. We have the toughest competition law in the world. Well, what good does it do to us? Are we more efficient? Are we developing more quickly than other parts of the world? I won't answer the question.
Very big debate. Jorge, last word.
Well, on that note, I think that regulation can be an obstacle to development, but it can unleash certain forces. If certain infrastructures are controlled by certain companies, and as a result of that, they stifle innovation by companies that could act or provide complements, then we want to free those constraints so that those other companies can grow. Europe has a problem, a significant problem, well, a number of difficulties in the digital space. And one of them is that we lack economies of scale because we have not achieved the single market really. And therefore, we are much more likely to be able to develop small companies that provide complementary services to the big platforms than develop the big platforms themselves as the Chinese or the Americans. So we may want to make sure that we regulate to free those market forces and facilitate that investment. But we have to do that carefully, because otherwise, we may, as we were discussing before with respect to innovation, do more harm than good. So, step by step, careful thinking is what I wish, the Commission officers these days.
Good. Well, Christopher and Jim, with apologies to you, I've been reminded that we should bring the session to an end. Thank you very much, everyone, for your stimulating comments. I don't think we've provided all the answers to all the questions, but we've given some kind of structure to the thinking which should go on in this area. And we look forward to discussing these issues again soon. Right. Thank you.
So hello to everyone. I think we are now going into the last part of this conference, and it is a pleasure for me to contribute to this debate with such an expert audience and in a leading and reference forum like the European University Institute. And the panel of that I am chairing and that I will be contributing then, giving the floor to Andreas Schwab, has as its title, The Future of the Digital Markets Act, which is a very timely issue. Every day, the competition alerts we receive are loaded with the news and updates on these initiatives of the European Commission. Although this is far from being merely a short-term issue, as we all know. Digitization has been the most relevant issue for competition authorities since the beginning of the new century, and probably the most challenging one. And it is a fact that we are discussing potential reforms of the competition policy framework with an intensity we had not done before. This relevance of digitization explains why the most brilliant minds in the area of competition and regulation are participating in so many reports, academic papers, and well, now webinars. So before dealing specifically with the current debates on the DMA, let me share with you the experience and knowledge we have accumulated on digitization and competition at the Spanish National Competition Commission, our National Competition on Markets and Competition, CNMC, which is both a regulatory and a competition agency. In our annual action plans, we have committed to devote more attention in sectors affected by digitization, both from the enforcement and the advocacy perspective. In the enforcement area, we have dealt with anti-competitive agreements regarding digital textbooks and vertical restraints in e-commerce, such as a ban by Adidas on online selling by its franchisees. We have also opened an investigation regarding possible anti-competitive practices by online real estate intermediaries related to the use of pricing algorithms. And in merger control, we have reviewed transactions involving food delivery digital platforms and online classified ads, mainly because we have this market share threshold that is capturing digital mergers. And we have imposed remedies where needed. Also, we have been dealing with this area in the advocacy sector, in the advocacy area as well. We have followed the implications in a wide range of sectors in the sharing economy with touristic accommodation, transportation, and urban mobility. We have also analyzed the application of new technologies to financial services, the so-called fintech phenomena. And we are currently undergoing a market study on online advertising, which we expect to publish in the coming months. It is thanks to these efforts that we are gaining a better understanding of the challenges raised by digital platforms so that we can provide an informed contribution to the debates on the potential policy responses. Of course, the CNMC contributed to the public consultations launched by the European Commission by responding to the questionnaires and by attaching a position paper to add some nuances to both documents. Actually, we made public our contribution last week. We uploaded our submission in our website. And this contribution reflected our multifaceted perspective as a sectorial regulator. We are a regulator in audiovisual and telecommunication services and as a competition agency. It seems now that the Digital Markets Act will cover the response to the digital gatekeepers. Apparently, the idea of a new competition tool, or at least its horizontal application, would be losing momentum, and the market investigation tool would be restricted to digital markets, so therefore regulated by the DMA. I would like to convey a first message in this, is that if we want a bright future for the DMA, it is crucial to connect the dots between what we want to tackle and how we're planning to do it. This is a message we also try to convey in our submission to the European Commission, before deciding the modes of intervention, it is essential that we define the gaps of the current competition and regulatory frameworks that we are facing. And given that apparently the horizontal application of the NCT is bound to be withdrawn, the implicit reasoning by the European Commission could be that these gaps only affect digital markets, so the market investigation tool should cover only digital markets. Well, our satisfaction as enforcers with this is mixed. On the one hand, one of the gaps of the current framework that we have in mind exceeds the scope of the digital issues. I'm referring to the tacit collusion, which sometimes can be hard to detect or punish with our current tools. Tacit collusion can be more hazardous due to digitization, that is true, for instance, through algorithms, but it can also occur in more traditional markets. On the more optimistic side, we deem it positive to use just one single tool, because two different tools, the NCT and the regulation for gatekeepers, would have created potential overlaps and regulatory uncertainty with the negative impact on the incentives for investment and innovation in sectors where business models are subject to constant disruptive changes. Now, the perspective on the merits of blacklist, whitelist versus gray lists, we'd like to point out that, well, this idea of a one-size-fits-all form of regulation seems to be discarded. Remedies and interventions were needed, and in our view, following a case-by-case approach must be imposed only to those undertakings enjoying some degree of market power and with the potential to distort competition. And we believe that we must avoid placing an extra burden on small and nascent firms, which would have benefited bigger players and incumbents only, preserving the incentives for entry and innovation. For instance, and we are witnessing this phenomena, some forms of privacy regulations have ended up benefiting digital platforms, absorbing an increasing share of web traffic and the data generated. And getting consumer consent is more difficult for small players than for digital platforms, which get this consent relatively straightforwardly, just the first time we log in. In general, regulatory compliance costs tend to be relatively more onerous for small firms and newcomers. Therefore, we welcome the fact that the regulatory response is likely to affect only a few firms with some degree of market power, even if this creates also some complexities that we all can imagine. Much has been written and said about the equivalence between the future DMA and the regulation of electronic communications. That could be kind of a proxy. I think that the equivalence is far from perfect, and there are differences between the challenges of digitization today and those of telecoms 2 decades ago. But I also see some common features, the chief among which is the use of the 3 criteria test, like the one we use in electronic communications. And if the answer of these 3 questions, can potential competitors overcome barriers to entry relatively easily? Is the market trending towards effective competition? And third, is competition law sufficient to deal with any competitive problems? If the answers to these 3 questions is no, then there is room for a potential intervention. But this requires a case-by-case analysis. That is, we prefer an open gray list to closed blacklist, whitelist, in order not to lose flexibility. We need to adapt to complex and rapidly changing digital markets. Now, let me, now that I have clearly explained our preference for a case-by-case approach, let me explain our issues on the definition of digital gatekeepers. In fact, you have been hearing a lot on this during previous interventions, and in particular, the difficulties in finding a legal definition on digital markets and submarkets. This is extremely complex, and we have vertically integrated subsegments or segments or markets in themselves. You have been able to hear to Martin Pates pointing the difficulties and risks of an arbitrariness in their expert report to the NCT. Same goes through for the concept of gatekeeper. It is very daunting from a legal point of view. It is true that some common knowledge is starting to develop regarding the role of gatekeepers, but we have to start by asking gatekeepers for who? Gatekeepers for what services? So it's not is far from being clear. So the definitions of digital markets and gatekeepers should be flexible and future-proof, because legal certainty, clarity, and predictability are of utmost importance in digital markets, already featured by disruptive innovation and high investments on research and developments. Last but not least, some thoughts on the institutional issues in the EU single market for digital services. This debate has to be taken as an opportunity to strengthen and deepen the European Union single market, particularly in digital services. We must avoid segmented national approaches, even if the new framework will have to be applied in some cases by national entities, because this would lead us to the partitioning of markets, jeopardizing the single market. Well, so much for the medium-term future of the DMA, but in any case, the immediate future of the DMA depends on the legislative process. And we have here Mr. Andreas Schwab, who is probably the best placed person to talk about this to us. So, Andreas, please, the floor is yours.
Kani, good afternoon to everyone. I'm extremely delighted that I get the chance at the end of that conference to say a few words. I've not been able to follow the whole conference, but my advisors have been, and I think I should come up with some contradictions to what has been presented, but also some support. First of all, to put it in a nutshell, why do we see a problem? Because we see in the last years that the bigger are getting bigger and bigger, and that's not a problem in itself, but we believe they get bigger and bigger without being better, but by being richer to kill a lot of companies that could be bringing, as one of the participants has said before, the possibility for new solutions by new entrepreneurs. Exactly, that's what we want to restore. We want to restore a situation where there is a real possibility for new solutions being brought into use and into the market by new entrepreneurs. And for the time being, we see a problem here. For that reason, we say that there is a need for legislation. So we don't want to become the biggest regulator. That's not at least not my idea. We want to be the smartest one because we want to allow in these quite, let's say, monopolized or difficult markets, again, a bit more flexibility and competition to unleash the potential that at the moment, from our point of view, is blocked. And we have to do it by changing the legislation because the ex post situation that the European Commission has to do takes in these very dynamic markets too much time. There are, so to say, different reasons. If you look back the last 10 years, there is a lack of resources to identify properly and swiftly competition issues. There is, secondly, a length of investigations that is far too long. And third, there is no use of remedies during the investigation or before the publication of a decision that declare the infringement. And the fast change of digital markets makes it all more complicated. That's together the result of the current situation. In digital markets, there are high barriers to entry, and we want to have lower ones. There are oligopolistic markets, and in a certain sense, there is exactly that situation that I've been describing. You can also say of a dominant market power. But we have critically to assess that this dominance has been able to grow by the fact that a lot of people and a lot of businesses have lost pace with the reality, and these big companies were able to overcome it. So we should be fair. They have been bringing lots of innovations, lots of improvements to our daily life, and therefore we don't want to punish them, but we want to make sure that that unleash of potential is possible. Now, on the Digital Markets Act, Kani, you have already been referring to it. Initially, we were thinking that there is only the Digital Services Act and this new competition tool that we have already been preparing with the platform to business regulation in the last parliament. But finally, we have seen that the Digital Services Act is only focusing on the e-commerce directive, and the Digital Markets proposal will focus on an improved platform to business regulation, as well as the new competition tool. The question, therefore, is what's the scope of the Digital Markets Act? To whom should it be addressed? From my point of view, it should be addressed to the big platforms that are gaining so much power to be able to dictate the rules of the digital markets. I know that for some of you, this is very strong, what I say here. I know that a lot of you are earning their money with exactly this, being defending the big ones or the other ones. But I mean, in politics, we are always sticking to the rule of law. But if we see that the rules don't work as we think they should work, we have to change them. And therefore, we want to address the scope of the Digital Markets Act in a way that we do not need a detailed and broad definition of the scope, because the aim of this regulation is to help and improving competition, innovation, and growth. That is our idea. We will see as to whether the Commission will come up with a great idea on this. And this will all depend on the question how to defend the gatekeepers. And I'm very grateful to you and the European University Institute to have come up with some proposals. We have been seeing some member states struggling with definitions. This is a very complicated issue because it has been said beforehand, we need always a case-by-case assessment. One can be seen as a gatekeeper in one market, can be seen as just a good competitor in another one, and therefore a lot will depend on this definition. And I have to tell you that I see some criteria, but I don't see yet the full picture of a real definition. In any event, I think to stifle innovation, we should not include into that definition too many companies, because if we do that in a too broad manner, the market will be overburdened with bureaucracy that no one can really like. The question will be how or what will be the conditions for these gatekeepers. And I have been seeing you, Kani, to argue for a grey list. For lawyers, that would be great because there would be on every acquisition, on every behavior, there would be a court case, but that could delay the process. Therefore, I think there will be a mixture. Some behaviors like the self-preferencing will rather be forbidden. That will be in some areas negative, but in most of the areas, I think the broad consensus is here that it would be rather positive. There will be other examples where we will not go for a black list proposal, but for a grey list proposal. And that is something that we will have to discuss after having seen the proposal. But in any event, and that's my last point, Kani, the question will be, how can be this policed? Who will be enforcing this? On the new competition tool, I think it's clear that it cannot be DG competition because they are those that after that make an investigation and make the punishment or the control and the decision. Therefore, it has to be someone else. And if we compare the regulation here with what we have seen in the past, it has been mentioned electronic communications, it has been mentioned electricity. I think we have to try to be smarter, not to fall into the trap of the last times. We have to really create a strong European authority because these markets are much more European than all other markets before. Then there has been the proposal by Professor Schweitzer at the beginning that the enforcement should be extended to the European competition network. We will have to see as to whether the legal service will allow these authorities to police at the same time as they develop policies and investigate the markets neutrally. That will be a difficult issue to fix. But in any event, I hope that we will get the proposal by the end of the year and that we can bring in lots of the constructive proposals, Kani, that you and your colleagues have been bringing forward. Thank you so much for your attention.
Thank you very much, Andreas. I don't know if there is any question. If there are questions, please use the chat facility and put your questions, please. While there are questions or not from the audience, I would like to ask you something, Andreas. How do you envisage in terms of time the process that we are now facing with the DMA? For when do you think that we could have something?
The Commission wants to propose their directive or regulation by the end of the year. Let's hope that we do it before Christmas. Then there will be a lengthy and maybe sometimes childish discussion between committees in the European Parliament who will be responsible. I think it's obvious that this proposal will be based on Article 114, and there will be strong references to the digital single market and to competition policy. And therefore, there is, let's say, not too many options available for this, but it will take time, I'm sure. And in this time, we hope that we can already start working. And if the proposal by the Commission is good, I would not doubt that we can come up with a vote in committee by the end of the year of the next year then.
Thank you, Andreas. In the meantime, we have some questions. There is a question to Andreas Schwab. What do you mean by a strong European regulator? Would it be a new separate EU agency or the Commission?
For me, very clearly the Commission, because we have to make sure that the competence of understanding the markets is centralized in the Commission.
Okay. There is another question. Germany is about to adopt its own reform. In particular, it will have a case-by-case assessment. The EC seems to be considering a different architecture, including strict red lines. Would you push for the German model at the EU level? And if not, why not? Thank you.
I think we should take the best model. And the best model is something which gives a clarity already at the beginning without being too inflexible. And I mean, there is still a lot to be thought, but I don't believe that we can fix everything in one word, because gatekeeper is a broad concept. It depends on the market, it depends on the size, it depends on the users, it depends on a lot of situations. But the approach that the German authorities have taken seems to risk to be a bit too often ending in the courts, and therefore not, let's say, efficient enough. But this is a first assessment. I think we have to find the right mixture here.
Thank you. Well, there is a question for me as well. And the question is, how do you see the DMA proposals interacting with the competences of the CNMC? Do you see a role for the CNMC in enforcement, in particular when it comes to the NCT? Well, as I was saying, we are an integrated agency. We are regulator and we are also a competition agency, and we see things from both the perspective of regulation, the most efficient regulation, trying to prevent from regulation situations of monopoly and other problems like that, and also from the competition side. I like to say that we have a hand for regulation and a fist for competition. And we do have market studies as well. We have the advocacy role, and in the advocacy we have market studies. So I have the feeling that for us it will be a very good tool. It can be a very good tool. It will complement what we are doing, but it won't change that much the tools that we are going to have even more with the ACN Plus implementation, because that will allow us to be sufficiently equipped. I think that that's what probably the best problem, the most important problem for all the national competition enforcers, is that being equipped, sufficiently equipped to deal with these digital issues that are not that easy. But yeah, that would be for me the answer. I have another question for you, Andreas. When you mentioned DMA should be limited to a small number of companies, this list should be fixed or evolve on a case-by-case basis. Thank you.
I mean, all legislation has to be general, so we cannot say it's Google and Apple. It has to be general, so we have to find conditions that are objective and neutral, that apply to this kind of gatekeeper companies. And therefore, for sure, it will be open to a case-by-case assessment. But just to say, let's do a case-by-case assessment looks a little bit general. I think we should limit the cases as much as we can. It has to be really the big ones that are concerned with this, and not a little bit everyone.
Okay, and there is a very interesting one here, which is, what if the European Commission would take a testing time in order to assess the efficacy of the new instruments and be able to adjust whatever necessary? The current articles 101 and 102 have been enforced many years. They were enacted in the initial treaties. So what do you think? And then I will give my
view
as well.
This is a very good idea, and it would probably help. But as you know, also in the European Commission, there are discussions on how to move these questions forward. And in a democracy, in the end, it has to be the lawmaker, the parliament, that decides. And therefore, we have to find a decision now, and we have to look that this decision is as much as integrative as possible. But we will have to be honest, we don't know what the future will bring. We hope that we will go for the right decisions, but for sure there can be a risk that we miss one element and that we have to fix it later. But we cannot just say in a democracy, leave it to the government, they should just do what they want. No, the key decisions in a democracy have to be done by the parliament, and that's the reason why the commission is it's them bringing us the proposal, it's not us bringing it. So we wait for the commission because they believe that it has to be decided now.
Thank you, Andreas. I would add something. From my point of view, in fact, this idea of sandboxes would be very good, but I have to say that the CNMC was happy when the new competition tool was put on the table, mainly because there was a gap in enforcement that we suffer. I mean, that is frustrating, which is a tacit collusion. Tacit collusion was one of the beauties of the new competition tool because it would have allowed us to deal with situations of oligopolies where you don't have elements that allow you to enforce the situation because there are no any form of contact, consensus, or anything. Well, unfortunately, that it seems that now it's not going to happen. And in that particular case, we do have Articles 101 and 102 from the very beginning of when the treaties were enacted, and we have been able now to. I mean, everybody knows that we have this gap in our context, in our framework, in our legal framework. So food for thought. I would have liked that very much to happen. Okay, there is, well, a question for both of us. If we agree there are gaps, it seems most agree, and consumers are already paying in some markets, is there not a sense of urgency accepting its inevitable risks? And yeah, that's, Andreas, you first, and then I will follow.
As you want, Kani.
Okay,
I mean,
go
please.
ahead. No, go ahead.
So, I mean, for sure, there is a risk of urgency. And fairly speaking, we have lost 10 years. But it's also true that in the last 10 years, we have understood and we have learned to understand much better the situation in these digital markets. So it's true that there is a sense of urgency, and for that reason, we will work hard. I would like to make another comment. At the moment, everyone is very much interested in that new competition tool that should scrutinize the markets that could be a risk. I just want to tell you that 4 years ago, we had a similar tool to be proposed by the European Commission, which was called SMIT, Single Market Information Tool. It was exactly the same stuff, but in general on markets, on the European single market. And there, the European business community was strongly against, because they said, if we go for that, there will be a discovery of our businesses, of our business ideas, of our business practices, and we don't want that. And this tool has unfortunately failed. Maybe it was a bit strong, but it was a tool very similar to the new competition tool. So if we were at the time in Europe against the single market tool, single market information tool, we will see the debates around the new competition tool that is focused on digital markets, because in the end, it's the same. The authorities taking a look into your business. And if this business is a fair business, you don't accept that they have a look inside. And the question is the digital market, are the digital markets so unfair that there is a right to enter them? On some companies, and I think the case in front of the European Commission have shown that there is a reason, but to generalize this on all companies, I think it's very dangerous. We don't know yet how we do that.
Okay, thank you, Andreas. I would add something regarding the gaps. Yes, in fact, when in our contribution to both instruments, what we were pointing out was that more time should have been, or can be still, devoted to the identification of those gaps. That there are gaps. I think everybody agrees that there are gaps. The question is which gaps are needed to be tackled immediately. What gaps do we have that cannot be tackled with the current framework? And in our view, it is important to identify well the gaps because we are talking about industries where innovation is key. And if it is true that we have platforms that are behemoths that are very difficult to control, it's also true that they can be extremely helpful in searching for information, in obtaining data, in connecting more information, in learning with artificial intelligence, because they can process lots of data. So we have to be very careful in what we regulate and how. And that is why our view was that it would have been better to first identify clearly the gaps that need to be regulated, instead of having this impression that we have to regulate because the current scenario is not working. And there is urgency. I agree with that. But well, maybe it is more a question of interim measures or injunctions. I don't know. But in order to have regulation, it has to be sounded regulation, and it is more tailor-made, a better regulation, I would say. Andreas, do you see a risk that the DMA proposal will become part of a very disputed topic in the European Parliament, as we saw it with the copyright directive? Or do you see a majority of MEPs avoiding such a split and disputes this time?
No, I don't think that the Digital Markets Act will be of that nature. I think it will be a rather, let's say, a common proposal where we have a lot of, let's say, interest, but also a lot of support. I think it's quite logical or quite understandable in the sense that most people believe that the companies that will be faced with these rules are rather non-European ones. I think we have to be self-critical on this, but I think as well that this can be a chance to find a good legislation that maybe in future will also be something that European companies have to be falling under these rules.
Okay, there is a question here to both of us. On the previous panel, Professor Padilla mentioned that Europe had a lot of edge innovators and not ecosystem innovators because of its lack of a single digital market. MEP Schwab has also said he expects more of a whitelist, obligations on gatekeepers to facilitate competition. What do you think of the risk of these common carrier type obligations making European startups even more dependent on the existing incumbent ecosystems? And there is a question complementing this one saying, ecosystem sounds well, but they are difficult to achieve. You never know what it will become an ecosystem. So what do you think about this common carrier or the whitelist type of obligations, making European startups even more dependent on the existing incumbent ecosystems?
So I should say now it's over to you to start, Kani, but it's up to you.
Well, honestly, the counterfactual is very difficult to assess, but it's true that we don't have a general framework that would allow for these edge innovators to flourish in a systematic way. I mean, we should create a kind of Airbus of the digital age. Honestly, I think that we have sufficient talent and knowledge in the European Union in order to have a Silicon Valley or something even better. And it is true that we don't have this ecosystem. So yeah, the mass carrier obligations could create a space for improvement there, but it could also be very rigid. That is why, again, we are favoring a case-by-case approach. But what do you think?
Thank you so much to have spoken first, because I got some ideas. First of all, I think the repetition of this Airbus stuff is something that I hear so often, but I think if you look on the facts, it's totally wrong because we cannot replicate it. We have no states anymore that have in similar sectors lots of shares, state participation. So the problem that we have been fixing with Airbus was that Italy, Spain, Germany, and France had a lot of shareholder power in companies that were better off without the states. And they have been pooling that together. That was a great idea. So the only solution there would be that the states that have still a shareholder capital in the telecoms would pool that as well. But unfortunately, we see that member states are not ready to do that, although that could be bringing the effect that you were just mentioning, even though if our telecoms have missed the point in the digital development a bit, not only because they were maybe missing the ideas, but also because our regulation was too heavy for them to focus on innovation in some areas. Having said that, I think it's obvious we want with that legislation, and the Commission and the Parliament altogether are on the same line on this, we want to help innovation to grow. But that can mean, in some cases, that the price for a startup 10 years ago or 5 years ago, because it was bought by Apple or by Google, was 1 million or 1 billion, in future will be much less. But there is no right to money in an economy. There is only right to good ideas and to innovation and to a freedom in the market. But the conditions of this market can always change. And I think the Digital Markets Act will change the rules. But it should change the rules for the better of the consumers, of the users, and thereby for the whole economy. Maybe not in the interest of everyone, but the rules that we want to set should be in the interest of 96, 98, 99% of the population in Europe and maybe even beyond. And that's the role of the lawmaker. We cannot look for some special interests. We look on the general interest that we want to defend. And here we need more innovation and better competition.
But do you think, and now let me ask you directly a question. Don't you think that sometimes the idea of too much regulation could kill the innovation as well? And well, my example, for example, with the privacy rules, the privacy GDPR now, it's being used, and that's my personal perspective, by most of the big platforms in order to protect their data sharing on the basis of the GDPR. So it's in fact being used as a kind of a shield and a sword by them, not allowing for other smaller players that need critical mass in order to be able to refine their algorithms and to have access to data. Now they encounter another barrier to entry that those big companies didn't encounter at the beginning. We believe that we have been protecting the European consumer with the privacy, but we may be chilling, we may be having a chilling effect on our European competition, for example, now.
Well, first of all, when the lawmaker has decided, it's not very popular to put this into question, because it's a matter of democracy, and in a certain sense, the European Parliament has to decide in a very cooperative manner. There are 4 political groups that have to work together. So I agree with you that too much regulation will kill competition. And therefore, I'm not in favor of too much regulation. And I was not in favor of, if you want to check this on the side of the European Parliament, I was not in favor of all the proposals that you have been mentioning. But I have to accept that, unfortunately, there is a certain belief in the majority in these cases that this regulation is needed. And then we have to work it out. But I agree with you that we have to be very careful not to over-regulate these markets, because we miss already investment in Europe. And if we now also overdo it with regulation, then we are finished in these markets. And that is exactly what we want to avoid.
Thank you, Andreas. I fully agree. A question for you: what could be the indicators of a success or failure of the DMA in the 10 years from now?
A very good success could be that we manage for one of the big companies to come up with competitive products to the other big ones. And at the same time, we manage to have an African, another American, and 2 European companies coming up with very smart ideas that will not be as large as Google or Apple, but that might be, let's say, as competitive and as interesting as Booking or another, let's say, smaller search engine that you may know, maybe eBay or whatever.
Okay, let's cross our fingers and hope for the best. There are many more questions to choose, but I think that We have already received the thank you for our participation, Andreas. Thank you, Cani Fernandez and Andreas Schwab. A great conclusion of our debate. We hope to have you both in Florence whenever it will be feasible. So we will meet in person in Florence. And thank you very much to all the participants of the conference. I don't know if the organizers would like to finally close this. So Marco, I pass the floor to you. Thank you very much.
Thank you very much, Cani, and also Andreas, for your intervention. Indeed, your concluding remarks complemented what has been discussed today with a sort of policy perspective on that complemented what has been said today by the practitioners and academics that have discussed the Digital Market Act. I would like to thank the panelists. I would like to invite all of them to turn on the camera, at least those ones who are still connected, who are still with us. It was a very long day. Let me also thank Elisabetta for the organization. As you can imagine, it was a massive effort to put together such a long conference in one day with so many speakers. And also, let me say thank you to the audience, to our attendees. We had an incredible number of registered participants, and I was so surprised that today we had between 150 to 250 people present at the conference, and we saw that we had a very lively debate via the chat. Of course, it's not the same like being together, present, discussing in Florence, but we know that we live very difficult times. We hope that next year we will be able to meet again in Florence, and perhaps this might also be a sort of innovation which will bring us a new format of policy events, more hybrid, that allow the connecting people in Florence with people online via Zoom or any other type of platform. So let me say that we will publish the PowerPoint presentation and also the video recordings from today on our event website in the coming days. You will also find a policy brief, which will summarize the discussion that we had to say. And as Professor Petit mentioned today, we will certainly continue the discussion about the Digital Market Acts. We will see what the Commission proposal will be in the coming weeks, but certainly we know that the proposal will be debated next year by the European Parliament and by the Council, and probably there will be further amendments, further changes, which will be also debated at the European University Institute, which is a European institute, so it's the best place to discuss such an important issue which has a European relevance. So let me say thank you to everybody. Thanks a lot for connecting today, and I conclude here this conference. Thank you very much to all of you. Bye-bye. Have a nice evening. Bye.